So thank you so much, everyone who has created time to join this discussion today, whereby we are going to have a very exciting discussion on a topic that is very important, not only for Africa, but also to the world. And today we are going to discuss the issue pertaining to whether there's any intersection or link between competition law and data protection, and whether those are two different legal regulatory regimes that should be regulated by different regulatory authorities. And I'm so happy because today we are going to listen from the academia, and then we are also going to listen from our practitioners. So I would like to introduce our speakers, and I will start with Professor Klaudia Majcher. Your second name is really difficult to pronounce. So Klaudia is a research fellow at the Global Governance Program at the Robert Schuman Center for Advanced Studies. And she's also affiliated with the Competition Law Hub as a postdoc fellow, and she's also a senior associate fellow at the Brussels School of Governance at the Free University of Brussels. So previously, and this is where we met, Klaudia was working as an assistant professor in the competition law and digitalization research at the Vienna University of Economics and Business. And she was writing, she did her PhD at the Free University of Brussels, referred as VUB. And her research focuses on digital and green competition law, digital regulations, and any other areas whereby there's an intersection between competition law. So she has published in several peer-reviewed articles, but one of her greatest achievements, and I'm really excited about this, and we should read it, is a recent book that she published with Oxford University Press in 2023, titled Coherence Between Data Protection and Competition Law in Digital Markets. So we are really excited because Klaudia is going to take us through the topic, the basics, and tell us more about this topic. Then from the academia, as most of us know, we will have Florence Abebe from Nigeria. She's the head of the Anticompetitive Practices Department of the Federal Competition and Consumer Protection Commission. And she's the lead competition analyst with the commission. She has participated in various statutory investigations, including the specific case we are going to discuss today, where the FCCPC investigated the WhatsApp privacy model or regulation. And therefore, she's going to tell us what really happened and give us the practical aspect of the coherence between data protection, consumer protection, and competition law. So she has been a key resource person with the commission in drafting of regulations like the abuse of dominance, respective agreement, leniency, among others. And she's also the focal person for the commission. So we're excited to have you in different platforms at the national and international level. And she obtained a law degree from the University of Leicester in the United Kingdom, and also a postgraduate diploma at King's College London. So I'm really excited to have the two of them and to know that we are going to have both perspectives from the academia and also from the practitioners themselves. So welcome, and I don't want to go into much details. We'll have Klaudia starting, and then we'll have Florence taking the stage. Thank you.
So thank you so much, Vela, first of all, for the invitation to participate in the discussion, and good afternoon, everyone. If in the meantime I have a little bit of a technical problem with uploading the presentation, thank you, Vela, for this. I find this topic really fascinating, very relevant, and something I've been working on for the past years, as Vela mentioned. So I'm really also glad to see that the Nigerian Federal Competition and Consumer Protection Commission has taken enforcement action in this area, and I'm really looking forward to hearing more details about this case from Florence later on. Well, I'm not sure because the presentation was there. Maybe just in the meantime, I'll just say a couple of words about what I'm going to talk about. So in my presentation, I really wanted to provide an overview of the interactions between competition and data protection from a European perspective, so the perspective where I come from. So after some general remarks, I will focus in particular on the Meta case, which is in fact a series of abuse of dominance decisions initiated by a decision of the German Competition Authority in 2019. It was a very consequential and interesting decision. And then I will talk a little bit about how data protection interacts with the Digital Markets Act, which many of you may know is a new legislative framework in Europe addressing certain practices by the so-called digital gatekeepers. Perfect, thanks so much. So if we could go to the next slide straight away. Great, so to start with the basics, we obviously know that digital markets have some distinguishing features, distinguishing characteristics, and I won't be going through all of them. I'm sure you're familiar with all of them, but just some. So zero price markets, non-monetary prices, ad-based business model, attention economy, high network effects or strong network effects, high switching costs, competition for the market rather than in the market. Then large tech companies such as Meta or Alphabet have also built the so-called digital ecosystems consisting really of various and usually strongly interconnected products and services. And quite importantly, we know that data, and in particular personal data, is really a key resource for many online platforms. So it enables them to deliver targeted advertising, personalized content, some personalized user-specific recommendations, etc. So really data drives platform business models and their competitive strategies. If we could move to the next slide, please. So here's just one ecosystem example of an ecosystem that is highly reliant on data, on personal data in particular. It is an ecosystem of Meta that will be then kind of relevant when we discuss the Meta case. So we know that Meta provides different services, Facebook, Instagram. Sorry, the previous slide, if we could go to the previous slide, sorry. Different services, so Messenger, Instagram, Facebook, WhatsApp, all of which really collect and process a lot of personal data. Data is then sold to provide personalized ads to generate revenue. So data in fact sustains and really is at the core of the Meta's business model. So the extensive use of personal data raises not really only concerns about market power concentration among platforms, but also about data protection. And the next slide, please. And in the EU, as well as in Nigeria, the right to data protection is a fundamental human right. In Europe, it is enshrined in the European Charter of Fundamental Rights. It is enshrined in our treaties. We also have the General Data Protection Regulation, as you know, that has the dual aim of protecting fundamental rights and freedoms, in particular the right to data protection and enabling the free movement of personal data. And it does so through imposing certain principles, rights and obligations on entities that process and collect personal data. And the next slide, please. And in fact, the fact that data protection is such an important value in the EU kind of resulted in the fact that the discussion on the interactions between data protection and competition law was in fact launched by the European Data Protection Supervisor. And in 2014, the EDPS, so it's an acronym, published this very influential opinion on privacy and competitiveness in the age of big data. And it was de facto the beginning of the discussion on the interaction between these two areas of law in Europe. So the EDPS said back then, the principles and rules on data protection, competition and consumer protection, they have all been designed to promote a thriving internal market, to protect the individual. They all kind of pursue similar objectives, and therefore a greater convergence in the application of these policies is really needed to kind of help us meet the challenges posed by the big data economy. A couple of years later, the EDPS issued a second opinion, which was equally important, where it really reiterated this message of a coherent enforcement of competition law, data protection law, and consumer protection law. And here it not only kind of reiterated the message, but also established or announced the establishment of the so-called digital clearinghouse, which is a cooperation platform or was cooperation platform to exchange information, for example, about potential abuses in the digital ecosystem, and really to discuss the most effective way of tackling such abuses, possibly through a coherent approach to competition and data protection law. Now, in a couple of weeks, actually, the EDPS will publish another opinion recommending, again, a stronger cooperation, so the so-called Digital Clearinghouse 2.0, so stronger cooperation between different regulators responsible for the digital economy. So the EDPS is saying there's a lot of overlaps, there's a lot of potential synergies between competition and data protection law, and that should be better explored, and therefore authorities have to cooperate in a closer way. Next slide, please. So now we know that data protection and competition law certainly differ in many fundamental significant respects. So the key one really is that data protection law is underpinned by the fundamental rights rationale, whereas we know that competition law is to a large extent grounded in economic thinking, at least in Europe. But we also know that these two areas of law share some common values, common objectives, and those are the ones that I've identified and described in my book. So the five that I wanted to just briefly outline is protecting individual welfare, broadly speaking, broadly defined. So welfare as individuals, as data subject, as consumers. Then strengthening individual sovereignty and autonomy, ensuring fairness in the market, mitigating power asymmetries, and improving transparency and mitigating information asymmetries. And I do not have the time to go deeper into these objectives, but those are the kind of high-level synergies that I've identified in my book. And the next slide, please. So I think that this convergence of values translates really into a two-sided relationship between data protection and competition law. And what I mean by that is that the interpretation of certain competition law concepts, notions, rules can have significant repercussions, either positive or negative, for data protection and vice versa. So for example, competition law concept of fairness or competition law concept of exploitation can really be interpreted in a way that acknowledges and addresses exploitative data protection practices by dominant players. So for example, excessive personal data collection. And in this way, competition enforcement can in fact strengthen data protection in addition to improving competition. So this is an example of a kind of synergistic relationship between these two areas of law. But there may also be conflicts between these two areas of law. So for example, a competition authority may approve a merger that is expected to have some negative privacy repercussions, thereby kind of creating a tension with the data protection law. So there are both kind of potential for synergies and for tensions between these two areas of law. And here in this slide, I've just listed some concepts that I've analyzed in the book and how actually the concepts of competition law are interconnected with data protection law and vice versa. And the next slide, please. So I think the fact that we see more and more areas where data protection and competition interact, this raises a number of very important questions that we've been kind of preoccupying ourselves both in Europe but also in other jurisdictions. So for example, a couple of broader questions. Does the consumer welfare standard encompass data protection? Can privacy be approached as a dimension of quality in a competition sense? Or is the competition law framework, in fact, flexible enough to address privacy-related harms? Then specific kind of merger questions, so how and whether should data protection be integrated into merger review? For example, where we can, in a way, expect that the merger may result in a combination of personal data, accumulation of personal data, and possibly a data protection violation. Then abuse of dominant related question, does access to personal data constitute a barrier to entry? Then which data related practices can in fact qualify as abuse of dominance? Can certain unfair data processing, for example, excessive data collection, constitute prohibited conduct under competition law? And then importantly, how we can foster cooperation, collaboration between competition law and data protection authorities. The next slide, please. So we've been asking ourselves this question, and there's obviously an intense debate going on about them. Now, I contributed with a couple of publications to this debate. The most important being, as Florence mentioned, the book where I analyzed really how data protection and competition law interact at the level of objectives, but also at the level of specific provisions. And I have also made several suggestions on how to address potential conflicts between these two areas, but also how to create more positive synergies between these two areas of law. The next slide, please. I'm obviously not the only one who has been talking about this issue. So there are other scholars, but also the OECD, for example, has contributed to it. So it has an interesting recent paper published some months ago on the intersection between competition and data privacy. So there's really an ongoing, not only European, but also a global debate on the issue. So these are some sources in case you are interested in this topic. And the next slide, please. So this intersection between competition law and data protection is obviously not only a theoretical discussion. So there have been in Europe competition enforcement actions, both in the area of abuse of dominance and in the area of merger control, where the issues surfaced really of whether and how to integrate data protection concerns, data protection issues into competition law. There are also new competition-related rules that I mentioned earlier that acknowledge really the relationship between market power and data protection. And here the most prominent example is the Digital Markets Act. So in a moment, I will discuss these areas, so abuse of dominance and in particular Meta case, as well as Digital Markets Act in a little bit more detail. But before we go there, I wanted to just focus for a moment on merger control. So in Europe, we've had a few interesting merger cases where the issue of data protection emerged. In which context? So if we take example of Google Fitbit merger, so here Google announced the acquisition of Fitbit, which produces wearable devices such as fitness trackers. Those devices collect a lot of sensitive personal data, for example, about health. And the concern expressed by data protection authorities here was really that after this transaction, Google will have access to a lot of sensitive data, sometimes health-related data collected by Fitbit, which may create privacy-related concerns. And in other merger cases, there was a similar kind of data accumulation issue at stake. Now, in merger cases, as we have seen from these decisions, the European Commission, the competition enforcers are really quite hesitant in a way to fully integrate such concerns, such data protection concerns, in their merger assessments. So, for example, they would not block a merger or ask for commitments just because a transaction may negatively impact data protection. But I think that they acknowledge, like what actually they did in Microsoft LinkedIn, that if the merging companies compete on privacy, on providing consumers with a high level, high standard of data protection, then data protection privacy can indeed be a competition issue. And kind of privacy-related restriction of competition resulting from the merger can be considered in a merger assessment. But still, in merger control, the data protection perhaps is not yet fully integrated. But I wanted to focus now a little bit more on the abuse of dominance case and the DMA, as I think that these two areas kind of are really good examples of a closer relationship between these two fields of law. So the next slide, please. So I wanted to start with the Meta case, and many of you may have heard about this case. It's actually a series of decisions, as I mentioned earlier, about abuse of dominance by Meta. It was launched by the German Competition Authority, decision issued in 2019, and kind of the final decision was issued by the or kind of not the final, but an important decision in this case was issued also by the European Court of Justice. And I wanted to talk a little bit more about these two decisions. So the next slide, please. So what happened in the German Meta case? So just very briefly, Facebook, so the German Competition Authority said Facebook has a dominant position on the German market for social networks. What does Facebook do? So Facebook, well, it was back then Facebook, right now Meta, but Facebook as a platform collects personal data not only on Facebook, but also outside of its platform. So for example, on Instagram, WhatsApp, but also on third-party sources. Then those personal data are kind of merged and very comprehensive user profiles are created and are later on sold to advertisers. Now, there was no choice for users in this respect, but they had to agree to this policy because otherwise they would not have access to the platform. So the German Competition Authority said this does not constitute a free consent because users are in a way pushed to consent in order to be able to continue using the platform. Then the Competition Authority said Facebook, in fact, has a special responsibility because it is a dominant undertaking. And therefore, Facebook, well, through this practice, violates the GDPR and exploits its dominant position in the market for social networks. What was the harm here? So the harm was exploitation, loss of control for users. Their right to self-determination was violated, there was some detriment to competitors. So the Competition Authority said this constituted an abuse of a dominant position in the social networks market in Germany, and Facebook either obtains a valid free consent from the users, or it has to restrict its data collection practices. And the next slide, please. So this decision was obviously appealed actually a few times, and I will not go through all these judgments, but an important judgment in this case was issued by the European Court of Justice, and it was issued in response to the so-called preliminary ruling questions asked by the Higher Regional Court of Düsseldorf. And I would like to focus for a moment on this judgment. So the next slide, please. So here, one of the main questions asked to the Court of Justice was the following one. So in the context of analyzing, examining an abuse of a dominant position by a competition authority, can a competition authority find an inconsistency with the GDPR, with the data protection law? So again, when a competition authority examines a potential abuse of dominance, can it rule that the investigated conduct is in fact incompatible with our data protection law? And the next slide, please. It was a very interesting question, in fact, analyzing the intersection between these two sets of law. And the Court of Justice said a few things here. So the first thing it said, quite importantly, was that GDPR compliance, the compliance with data protection law, is in fact a relevant factor in competition assessments. It said more precisely that in assessing conduct under Article 102, so under abuse of dominance rules, non-compliance with the GDPR may be a vital clue in establishing, in fact, an abuse of a dominant position. So a very clear kind of consequential statement. The court said later on that access to personal data and data processing are in fact a significant parameter of competition, and therefore excluding data protection rules from a competition law analysis would actually disregard our economic reality, what's happening in the market, and would in fact be liable to undermine the effectiveness of competition law. So a very clear statement that competition authorities can look into data protection law, into the investigated conduct's compliance with data protection law when they analyze whether a certain conduct is an abuse of a dominant position. And the next slide, please. There is a limitation to this. What if the investigated conduct, so the conduct investigated by a competition authority or a similar conduct has been already subject to a decision by a data protection authority or a court? So what if a data protection authority has already issued a decision on, for example, the compliance of Meta's data processing with the GDPR? And here the court said, in this case, a national competition authority is really not allowed to depart from the conclusion of a data protection authority, but it remains free to draw its own conclusions from the competition law point of view. So, for example, if a data protection authority said that Meta's data processing is illegal under the GDPR, then a competition authority obviously cannot say the opposite, but it can still draw on competition conclusions. So it can say, even though the conduct is illegal under the GDPR, it is legal under competition law, or the other way around. And the next slide, please. And here, importantly, also the court said that competition and data protection authorities, in certain instances which the court listed in the judgment, must cooperate with each other to ensure the consistency of application of the GDPR, so of data protection law. And here it referred to the so-called duty of sincere cooperation between the authorities. So again, an important statement on in a way, institutional aspects of this topic. And the next slide, please. So besides analyzing this question of whether or not competition authorities can take into account what's happening in data protection law, when assessing abuse of dominance, the Düsseldorf court also asked the European Court of Justice about a specific question related to the interrelationship between user consent, so this is a concept taken from data protection law, and a dominant position. And specifically, the question posed was the following: is consent to data processing given to an operator of an online social network freely given if that operator holds a dominant position in the market? So when we give consent to a dominant firm, to a powerful platform, is our consent really free and compatible with the GDPR? And the next slide, please. And here, quite interestingly, the court said dominance is in fact a very important factor in assessing whether consent is free, is valid. So the court said a dominant position does not, as such, prevent the users from giving a free consent, but the fact of dominance must be taken into consideration and is an important factor when establishing whether consent has been freely given. And why is this the case? Because the issue of the fact of power, the fact of dominance can in fact affect the freedom of choice of users and can create what the court called a clear imbalance of power. Imbalance meaning, or imbalance that may allow a dominant firm to impose on users certain unfair processing conditions. And then the court said users in this case need to be offered an equivalent, less personalized alternative by a platform like Meta in order for their consent to be freely given. So they have to be given a choice. They cannot be pushed into consenting to certain data processing activities without being given a choice. And the next slide, please. So some key takeaways from the case, as I've mentioned earlier, so the court said GDPR compliance is a very relevant factor in competition assessments. In some cases, it may be a vital clue to decide whether, for competition authorities to decide whether certain conduct constitutes an abuse of dominance. Then the court said competition and data protection authorities must sincerely cooperate with one another. And on the specific issue of consent and dominance, the court said dominance is an important factor in assessing whether consent is free. So really an important judgment that goes in fact to the core of the relationship between competition and data protection, not only really from the substantive point of view, but also from a procedural, institutional point of view. And I wanted to go to, for a moment, to the DMA. And Vela, if I may ask you, how much time do I have? Okay, I'll just go ahead for now. I'll take a couple of minutes with this. So I wanted to talk about the DMA, which you may know is a new ex-ante regulation. It is applicable of May last year. The DMA has two main goals: to ensure market contestability and to ensure market fairness. So the goals are really similar to the goals of competition law, even though as such the DMA is not competition law, but it is a competition-related ex-ante regulatory instrument. So the DMA applies to the so-called digital gatekeepers. So in the DMA, there's a provision that lists certain criteria, qualitative and quantitative. And if those criteria are met, then a company should be designated as a gatekeeper. And the next slide, please. So by now, we have 7 companies that have been designated as gatekeepers. So Alphabet, Amazon, Apple, Booking, ByteDance, Meta, and Microsoft. And in line with the DMA, those companies need to comply with a list of obligations and prohibitions for their so-called core platform services. And the next slide, please. So I wanted to say just a couple of words about one specific provision of the DMA, one specific article that interacts, I think, in a quite interesting way with the GDPR. So this is Article 5.2 of the DMA, and this article prohibits specific forms of data processing, data combination, data cross-use, unless end users are presented with choice and provide consent. So let's remember that the DMA is a competition-related regulation. It is not data protection, but it includes this clause that consumers have to be given consent for a digital gatekeeper, for a very powerful platform, to conduct certain data protection practices. So, for example, gatekeepers are not allowed to track users outside of the platform for the purpose of providing targeted advertising, if they have not obtained from users a valid consent. So the DMA actually explicitly refers here to the GDPR, saying that consent needs to be GDPR compliant. So this provision really in a very explicit way merges a competition related regulatory provision with data protection law. And the next slide, please. So I wanted to say just still a very few words about one business strategy that has already triggered an investigation under this provision, so under Article 5.2. And this strategy, this model is the so-called pay or consent model, which was introduced by Meta in October 2023. And in line with this model, users can either consent to personal data collection and processing or pay a certain amount, and I think it was around 10 euros per month, to opt out of data collection and opt out of advertising. So the question that emerged here, not only from competition law, but also from the data protection law, is really whether this practice is legal, and specifically, is our consent really free if the alternatives to consent are to pay for the service or not to use the service at all. And in fact, in line with the empirical evidence, when users are asked or presented with such a dual choice, so to consent or to pay, almost 100% of users choose to consent. And this is not because really we don't care about privacy, but because the alternatives, meaning either paying or abandoning the service, are just not good enough. And so this practice has been recently investigated by some national data protection authorities. Also, the European Data Protection Board issued an opinion saying that in addition to these two options, so paying and consenting, users need to be offered a third alternative, which is a free service without personalized ads. And interestingly, there still is an ongoing DMA investigation, but the preliminary findings were issued a few months ago on this question. And the European Commission said this practice is in fact also illegal under the DMA. And the next slide, please. So here we have the statement of our competition commissioner who said, our investigation aims to ensure contestability in markets where gatekeepers like Meta have been accumulating personal data of millions of EU citizens over many years. Our preliminary view is that Meta's advertising model fails to comply with the DMA. We want to empower citizens to be able to take control over their own data and choose a less personalized ads experience. So interestingly, really the views of the European Data Protection Board, data protection authorities and competition authorities were fully aligned in this case. And the next slide, please. So the most recent development here is that Facebook, in fact, a few days ago announced a change to its model. So in addition to offering the pay or consent kind of options, it will also be offering to users based in Europe a less personalized option, which will be a free option, where they will use less data to personalize ads. So they write, in the less personalized option, we will use significantly less data to show ads. So probably these ads are going to be contextualized ads or not so personalized ads. Maybe next slide, please. Sorry, so this is already a cooperation initiative, so my last slide really, but by the previous case, I really wanted to show how strictly competition-related regulation and data protection are in the context of, specifically in the context of consent. And this was also evident in the Meta case. So not only under competition law, but also under this new Digital Markets Act, we have the situation where really consent and power interact in curious ways. And I think I'm way over the time now, so I will stop here and we can come back to the issue of cooperation later on. Thank you.
Thank you so much, Klaudia, and thank you so much for the presentation. It was detailed. It was very important for us to have this conversation first. And I know we have burning questions. I have burning questions, but Florence also has a very interesting case study from the African continent. So we'll go straight to Florence.
Hello, everyone. And thank you, Vela, for having me. It was really enlightening hearing Professor Klaudia speak about the Meta case. I think that she has covered it perfectly. But again, let me come from the very more practical and experiential point of view. And let me start by issuing a disclaimer. I'm talking about my personal views on the case, and they are not necessarily binding on the Federal Competition and Consumer Protection Commission. I think a very good way to start would be a basic understanding of the legal framework in Nigeria. By way of institutional history, the Federal Competition and Consumer Protection Commission was originally the Consumer Protection Council, and it only had one mandate, which was consumer protection. However, in 2019, with the presidential accent to the bill, the then bill, and now the Federal Competition and Consumer Protection Act, we now have two mandates, not just consumer protection, but also competition. And you will find in the course of this discussion why that became an issue at some point in the conversation. And you've heard Professor Klaudia also talk about the intersection between competition and consumer protection and all of that. But besides the FCCPA, we also have the Constitution, and that's the Grundnorm. That's the most fundamental law in the land for which the FCCPA draws its legitimacy. The Constitution, I believe is Section 37, and makes it very clear that Nigerian data subjects have a fundamental right to privacy. Their right to self-determine how their data is collected, is used and democratized. We also have the Nigerian, at the time when this investigation started, we didn't have the Nigerian Data Protection Act, which we now do. But we had the Nigerian Data Protection Regulation, and that was also, again, responsible for the regulation of how data was democratized and the portability of data. So in terms of scope and jurisdiction of the Federal Competition and Consumer Protection Commission, Section 2 is very clear. As long as it is a commercial activity that has effects in the Nigerian market, the jurisdiction of the FCCPC will apply. We also have a Section 17 that allows the Commission administer and enforce any law that borders on consumer protection and competition. And with respect to consumer protection and competition, and subject only to the Constitution, the supremacy of the Federal Competition and Consumer Protection Act is established. So that's the legal framework, and that provides the legal basis for which we're able to look into this Meta case. Sometime in 2021, I believe it was January 2021, the Commission became aware that Meta had updated its privacy policy. And what was shocking to members of the panel was, the investigative panel, was the fact that Meta had originally informed the Nigerian data subjects that if they failed to update their privacy policy by, I believe, sometime in May of that year, 2021, they would no longer be able to use the WhatsApp services. And that became quite suspicious. And so what the Commission did was immediately issue what we call the order and notice to show cause as to why we shouldn't consider this a serious investigation to look into. And Meta's response was, oh, don't worry, this is not a big deal. There's no consumer protection concerns or competition issues that our policy raises. There are no consumer harm. We're only just trying to be transparent. We are not sharing or doing anything different from what we were doing in our 2016 privacy policy. Again, that response for the Commission was considered suspicious, and members of the panel decided to now look in depth at the privacy policy and compare it with other privacy policies all over the world, particularly in Europe, because we found that the regulatory environment is quite similar with that of Europe. And we then developed our theories of harm, which includes definitely a lack of consent, and we've seen it even in the way that Meta operates, even in Europe. The lack of consent, we saw a lack of compliance with the Nigerian data protection regulation. Again, you can't say to someone, it's a take it or leave it situation, a pre-tick box. In essence, if you don't accept this privacy policy, you can no longer use the service. That was, so the Commission concluded that everyone who accepted the privacy policy at the time was under duress. And so that was an established theory of harm. We did recognize that, or accepted the position that Meta took with respect to, oh, nobody lost functionality in the period, even though, yes, we did threaten them, but, no one lost functionality. They all accepted and gave consent. And we said, no, that consent wasn't freely given. It wasn't in compliance with the Nigerian data protection regulation. And so we would say that it was an absolute lack of consent. When we compared that with the Nigerian data protection regulation and the general data protection regulation that applied in Europe, we also found that Nigerian data subjects were discriminated against. For instance, in Nigeria, once you have given that consent, even though it was still not freely given, but once you've given that consent, you cannot withdraw the consent. This is very unlike in Europe, where you are able to withdraw the consent. But more egregious was the fact that the Nigerian data protection regulation sort of mirrored the general data protection regulation. So there was no reason why Nigerian data subjects could not get the same or similar protection when it comes to withdrawal of that consent, particularly because you have mandated them and you've given them a pre-tick box to grant their consent or not use the service. And then if they did change their mind, I'm sorry, the only way to withdraw your consent is to delete the app. And so we found that to be troubling. So another theory of harm was the tying and bundling. What had happened was that Meta was using the privacy policy to tie their WhatsApp market with their Facebook market and all of the other Facebook family. For instance, whatever data WhatsApp is able to collect, whatever cookies they're able to embed in your phone, whatever tracking system that they have, once they've gathered that data, they're able to profile you. And once they profile you, they can share that data with other Facebook companies. And this is not just Instagram or Facebook. It also includes third parties, and for all of this data that is collected, you just get this one consent pre-tick box, and that's it. They're going to share your data. So that was, these were the theory of harm for the commission, and we found it to be one, an unfair business practice and an abuse of dominance. And we're able to do this by delineating the market. Of course, this was another challenging aspect of our work, and Meta had insisted that the market was global in nature. However, we took a more narrow point of view. We looked at the geographic location in the sense that in terms of geography, the effect was felt in the Nigerian market. And so there was no way you can say that it was a global market. We also looked at the privacy policies. We realized that Meta had privacy policies for different regions. And so you can't, on the one hand, say you're a global market, but then you've delineated the market yourself with your privacy policies, as it were. We did a market study also to support a lot of our findings or to corroborate those findings. We also were able to look at the unique products that Meta was offering compared to a Facebook, for instance, where is double or multi-sided. The WhatsApp market was single-sided. It was a one-sided market, zero price, as they call it. But then the kind of data that was being collected was excessive. When we looked at the market participants, we saw that Signal somewhat operated in the market. Telegram operated in that same market. Meta, WhatsApp was in that same market. They were doing similar things. However, Meta would like us to believe that it was a market for the attention of consumers. And so we could bring in the LinkedIn, the YouTube, Netflix, and Zoom, but we looked at the unique features of the market. We saw that it was single-sided. We saw that it was contact-based. We saw that it was more family, group, church type friends related as opposed to a marketplace like Facebook. And so we were able to say, no, we understood what the market definition should be. We will take it, we'll take a more narrow look at the market. We decided who the market participants was. Again, we relied on the economic analysis in the market study. And then we looked at other substitutability, the high switching costs, because most of the data subjects were using WhatsApp. They didn't want to switch from WhatsApp to any other platform because they didn't see any reason why. Most of their family and friends were there, and the switching cost was high in the sense that it was going to take time to get your family and friends to move to a different platform just because of you. We also looked at the quality issue. We agreed that the more data was collected, which we also analyzed that, we saw that Meta was collecting unnecessary data points than when compared to other market participants. And the likelihood of collecting this amount of data when compared to the security of such data was very slim. I mean, the more data you collect, there's a degradation in the security of that data. And that was how we looked at it. And so we found that beyond the amount of data that Meta was collecting, we looked at their technological links, and we came to a finding that indeed, whether it's with respect to the market structure, the amount of data points being collected when compared to other market participants, WhatsApp's technological link with Facebook and Instagram, and the difficulty that other competitors will face in expanding because of the high network effects and lock-in effects, we were able to come to the conclusion that you are dominant, and your conduct of denying Nigerian data subjects their rights to self-determine how their data was democratized, shared, collected, stored, was an abuse of that dominance. The fact that you were tying your WhatsApp market to your Facebook and potentially Instagram and other third-party markets was anti-competitive. And so, the discrimination against Nigerian data subjects with respect to how Meta chose to comply with the Nigerian Data Protection Regulation as compared to the General Data Protection Act in EU, we were able to come to the conclusion that we had met the standards of proof required for us to bring Meta back to compliance with the Nigerian law. And so we issued a report. We showed them our sources of information. We gave them ample opportunity to respond back to the commission with respect to its position. Again, Meta stuck to their guns as far as they're concerned. Your conversation with your friends and your family is still end-to-end encrypted. Indeed, we're collecting a lot of data, but we're not doing anything different from what we were doing in 2016. And so we were just meeting the transparency requirement. We are not dominant in any relevant market. As far as Meta is concerned, the market is global, it's digital, and so there are no narrow definitions of that market. Again, all of this, the commission disagreed with Meta and has asked Meta to unbundle whatever infrastructure has been integrated to ensure that they do not comply with the regulatory requirements in Nigeria. We've also insisted that they must seek consent for any data that they are collecting pursuant to law, and ensure that the Nigerian data subjects' rights to self-determine the use, storage, processing of their data is restored. I'll stop here, and I'm happy to take questions.
Okay, thank you so much, Florence, for giving us a detailed information on the WhatsApp investigation case. Maybe I have one question, then I'd like Klaudia to comment on your presentation in any way possible. One of the implications of the WhatsApp investigation in Nigeria was the threat by WhatsApp to leave Nigeria. And I'd like to hear from you how you are able to handle this.
I mean, well, I heard about the threat. I mean, it didn't come formally to the commission, and my understanding is it's a faceless threat. WhatsApp didn't come out publicly to say that. It was in the press. But then, I mean, what's pleasing is that Nigerians now understand to some extent. Meta must know that that threat was an absolute mistake on their part if they did allow that statement to come out. And the reason is you saw how Nigerians reacted to that statement. And Nigerians said, oh, by all means, we'll go to Telegram, we'll go to Signal, we'll go to your competitors. And so we've not seen any more of that statement come up anymore. That's because we have to be very clear. A business must comply with the law. And the fact that you provide some kind of service to the Nigerian market, the Nigerian market is a big market. There are many consumers and data subjects in Nigeria. You don't want to mess with them, for lack of a better word. And so how Nigerians reacted was the most appropriate response to that statement by Meta.
Okay, thank you so much. So to the participants, if you have a question, kindly raise your hand. So I'll go to Klaudia. I'll allow you to say what you'd like to say, but also I'd like to know how can we enhance compliance of these big tech companies? It seems like in the EU, the DMA provides an opportunity for this compliance, but how can we cooperate in order to enhance compliance in developing countries?
So thank you so much, first of all, Florence, for the presentation. It's obviously a absolutely fascinating case, and it's also great that that in a way a coherent approach is emerging between very different jurisdictions in a way, but very different in some respects, but also similar in some respects, because as you mentioned, the Nigerian data protection law also has been modeled to a certain extent on the GDPR, so offers very similar protections to Nigerian citizens. But in any case, I'm really happy to see this kind of emerging coherence, convergence of approaches really between the jurisdictions. Because when I was hearing about your theories of harm, I mean, for example, the right to self-determinate, it's one of the really rights that emerged as a kind of a starting point of the data protection privacy laws in Europe. And it has been actually, in fact, relied on also by the German competition authority when the authority formulated its theory of harm. So it's it was fascinating for me to hear that that this theory of harm was also adopted in this case. And obviously the theories of harm slightly differ because in your case there was a question of non-discrimination as well, which we did not have in Europe, but also a very kind of overall a very progressive approach, I think, to enforcement of competition law and to the in a way idea of what competition law should be all about, what values it should promote. I mean, it's maybe not as controversial as the decisions of competition authorities in Europe because you have a joint mandate, right? So consumer protection and competition law. So that makes it a little bit perhaps slightly maybe not easier, but perhaps less controversial to issue such a decision. But in any case, like a very, I'm really impressed by the analysis and by this very progressive in a way step. I mean, in Europe, we're still debating, you know, and there's a lot of controversies whether what the German competition authority has done back then was, in fact, you know, a good way forward. But then we also got last year the European Court of Justice case that in fact confirmed this approach that that such a case can actually legitimately be brought forward and pursued and decided under our competition laws. So many thanks for presenting the case. On your question, Vela, it's $1 million question, right? So I think non-compliance has been, in a way, or you know, it's kind of fines have become an operational costs for some of the companies, right? So so the hope is obviously that the DMA, through a stricter approach, will change something. And I was extremely happy to see. So always the in a way the problem was the timing of the decisions. So the decisions have like take years to in a way to be, or not decisions, but cases take years to in digital markets, whereas digital markets are obviously developing extremely fast. So it is very difficult to kind of stay up to date, catch up, and react quickly. So the hope is that the DMA, in fact, will provide this instrument to react quickly and to be able to capture some of the serious infringements. But I don't have a good question, I think, to you. We will see how the DMA will operate, whether actually it will bring the expected changes to the market in terms of fairness and contestability. These are very important goals that I think, in particular in digital markets, really need to be pursued in order to kind of introduce some dynamism in this markets. But I also had a small question to Florence, if I may, because from what I understand, you cooperated also closely with the Data Protection Authority, and I was just curious how this cooperation actually, in a way, was structured, or if you could say a little bit more about this institutional aspect.
Indeed. So in 2021, when we started to look at this case, Nigeria didn't have the Nigerian Data Protection Commission that we had. It was a department at the time under NITDA. And so what we did was we wrote to NITDA and we informed them that, you know, the commission is looking at this investigation and would really need their help. Great thing is we had negotiated a memorandum of understanding with NITDA. And so what they did was they immediately called a meeting. We told them about our theories of harm, and we said we needed information, any information whatsoever. So one of the things that NITDA gave us was one, the fact that there was this discrimination theory of harm that we should look at, you know, pursuant to the Nigerian Data Protection Regulation and GDPR. And so we had to do a comparative analysis of both legislations. And then they also gave us the data points that Meta was collecting, as opposed to Telegram and Signal, which we had expressly requested for that. And so they gave us those data points as best as, you know, in the manner that they had stored them. And so that was very helpful. However, like you had earlier said, these types of investigations take time, and we're hoping that, you know, the DMA would probably help other countries to see why we need to develop our own ex-ante regulations. But because they took time, in the time that we were investigating, the Nigerian Data Protection Bureau was born out of NITDA, and it became a standalone agency of government. We then went to them as well. We negotiated MOUs in that period, and, you know, that's been executed as well. We now started working with them. By this time, we had developed our theory of harm. We had gotten responses back and forth, and we presented that again to the Bureau. Again, the Bureau now became a commission, and the Nigerian Data Protection Act was passed last year, giving enforcement powers to the Bureau, which is now a commission. And so again, at the reporting stage, we subjected the report to members of the commission. They looked at it. Meta had requested for a meeting after we issued our final report, and the Nigerian Data Protection Commission was in attendance, and it was very interactive. They participated in it. It is a stellar way for agencies of government to collaborate. The use of an MOU wasn't just about writing it in a document. This was a practical example of how government agencies should work and the significance of collaboration in making sure that we're speaking with one voice and we're stronger together. I think that has really set the standards for even in other sectors where competition analysis will be done.
Okay, I hope, Klaudia, you've received some information. So Damola has raised his hand for a long time. So Damola, can you ask your question? And Florence, if you have any question for Klaudia, you can also ask her.
Yeah, thank you very much, Florence and Claudia. That was a very fascinating session. So, to be honest, Claudia already asked the question I really wanted to ask Florence, but I'm just curious about future enforcement, future similar enforcement that involves a convergence of institutions. So, for example, in Canada, we have, or they have, a group called Digital Regulators Forum, DRF. It consists of the Competition Bureau Canada, the CPC, the Office of the Privacy Commissioner of Canada, and the Intellectual Property Office. Do you think and this question is to Florence, do you think having this similarly formalized institutional collaboration would actually strengthen joint enforcement beyond what an MOU would do? Because in the digital economy, the fight is beyond the Privacy Office or the FCCPC or even the Corporate Commission. You know, in the digital world, several enforcement bodies really need to collaborate, not as a matter of afterthought, but deliberate collaboration. So yeah, I would love your thought on that, Florence. Thank you so much.
Thank you so much, Demola. And that is, I mean, again, this is a conversation that is way above my pay grade. Nonetheless, by experience, I don't know if you know about the digital money lending investigations that the FCCPC also did. What we had done was develop a task force. And so we wrote to different sector-specific regulators to come in. And it's very important. Collaboration is something that we need. One, because it brings in specialization. And so having multiple sector-specific regulators form some kind of task force that enables us learn in the process how to leverage on our strengths and how to ensure that, you know, the cracks are covered is very important. And so that's something that the FCCPC has championed, whether it's in the digital money lending investigation that we did, or this Meta investigation that we've just concluded, or in any other sphere. And so what I didn't mention in the course of my presentation was we went beyond even just getting local sector regulators involved. We did speak to the German Competition Authority. We spoke to the Egyptian Competition Authority, Kenyan Competition Authority, South African Competition Authority. We made sure that we were relating with people. And so any opportunity to form a task force, legitimize that task force, empower the task force to make sure that Nigerian consumers are given the best. That is our mandate as the FCCPC. I hope that answers your question.
Okay, thank you. So I hope, Damola, you're satisfied with Florence's answer. So Florence, I have one question for you, and it relates to the justification of data protection when there's a competition violation. If you ever faced, what are some of the defenses that Meta discussed during the process?
Yeah, like I said, one of the things that Meta has said is that their technological links is such that it would be extremely expensive to delineate their WhatsApp market from their Facebook market. But they do agree that although there's no Chinese wall, that those services are offered differently. And so the law is, the position of the FCCPC is clear. Any integration or infrastructure that is an illegality must be unbundled, And so whether that's their efficiency claim or not, as far as the commission is concerned, it is an illegality. If you're going to gather this amount of data from Nigerian citizens, get their consent. Get their consent. Another thing that Meta kept saying to us is, besides consent, if you look at the Nigerian data protection regulations, there are other reasons why we can collect this data without getting consent. Legal obligations, contractual obligations. But then again, the law is very clear. It's even your contractual obligations cannot be one-sided. You must still make sure that there are certainty of terms for which the person you are negotiating those contracts with has his rights protected, and he is entering into this contract freely. So I can't think of any defense that Meta gave in response to the investigation that should have been considered to the extent that the commission wouldn't have reached the conclusion that it did. Oh, let me also say that the matter is currently on appeal at the Competition and Consumer Protection Tribunal in Nigeria.
Okay, so I can see our time is almost up, and maybe does anyone have a question to the presenters before they give their final remarks? So, Klaudia, I know when you're talking about the interlink between competition and data protection law, because of limited time, you did not really go into details, but I would like you to briefly say something about data and power symmetries and why we should really care about this.
Thank you. So, as the Court of Justice also said in the recent Meta case, the position of power can really result in large power asymmetries, right? Like not all consumers are vulnerable, obviously, but we vis-a-vis dominant platforms unfortunately expose some vulnerability, especially in context of take it or leave it kind of options. So if we have take it or leave it option, I think that by now it is established, and also Florence has mentioned that this has been their conclusion, that in such a case, consent cannot be freely given, that users came to, fortunately or unfortunately, depend on digital platforms in their daily lives, for their work, for their interactions with others. So either consenting or being denied an access to service really exposes this massive power imbalances. And when we have no other options in a way there, then I think our vulnerability is of an extent that it should be addressed through competition or data protection means. So I think in particular in this context, the power asymmetries in a way come to fore. So particularly in the context when we're faced with this idea that we cannot access a service if we do not provide our personal data in exchange. So in Europe, there have been recently these significant developments triggered by the DMA that resulted in Meta, for example, offering 3 options right now. So pay, consent, or we are offering you a free service but with less personalized advertisement. And I think that this is a development, kind of a business model development that we want to see, and that hopefully will address some of these imbalances that we are currently seeing in the digital markets. Thanks.
Thank you so much. And just allow me, I'd forgotten this question because we've focused more on the exploitative conduct relating to data protection. And maybe in 1 minute, tell us something about the exclusionary conduct and how the EU has been able to address this issue and some of the measures.
Yes, so I mean, we have not really had a case yet, right? So that dealt with exclusionary, really kind of theory of harm. So I think exploitative theory of harm, obviously it is a bit more tricky theory of harm to pursue because of the kind of quasi-regulatory nature of the notion of exploitative abuse. But I think, it has been confirmed also by the Court of Justice that something like that is possible to do. So we have exploitative abuse kind of for a reason in Article 102, and I don't see why it should not be used in such cases. When it comes to certain exclusionary theories of harm, I think data protection could figure in some of them, but I think so for example, if a dominant platform employs certain strategies because of its dominance, employs strategies that kind of exploit consumers when it comes to their data. It can do it because of the dominance. Other firms cannot, rely on such piles of data. So they're in a kind of a little bit unprivileged competitively position as compared to dominant platforms on the market. So there can be perhaps potentially some exclusionary theories of harm linked to the ability to use personal data. But I think when it comes to data protection really and privacy, the exploitative theory of harm, I assume, is the most kind of prominent one and promising one. Thank you.
Okay, thank you so much for that information. So Florence, as you conclude, I'm one of the person who was extremely proud of the FCCPC for this investigation against WhatsApp. And I would like to hear your opinion regarding to what should developing countries learn from this, and how can developing countries, especially competition authorities, position themselves in a way that they can enhance compliance of their data protection law and competition laws in regard to big tech.
I think African competition authorities need to think strategy. They need to think collaborative. They need to think coordinate this approach. When we started looking at this case, the first country we called was Egypt. We said to them, we needed to look into this case. Egypt said, well, the problem that we have is we are not a consumer protection agency. We are just competition. And so it's going to be a very tricky one. So what I would say in such a situation is we need to interpret our laws a bit more broadly and creatively as regulators. We need to share our experiences. We need to also prevent overregulation, of course, because we don't want to stifle the competition. We don't want to kill the innovation, and we don't want consumers to now bear the burden of this. I mean, a business that comes out to say, we're going to leave Nigeria if, FCCPC doesn't, doesn't cancel this penalty or sanctions against us. That's threat. Now, if it was a smaller country, you can imagine what that would do, what would happen. And so we're bigger and better together. When we come together, we're able to stand up as a continent against unethical and unfair business practices. So again, my recommendation for African Competition Authority is let's learn from each other, let's share our experiences, let's think strategy, let's think collaboration, and let's be more coordinated in our approach.
Okay, thank you so much for the strong conclusion. And because we've come at the end of this session, I want to thank Klaudia and Florence for agreeing to talk about this important question, because when the FCCPC shared its investigation, there was a lot of questions going on in various groups that I'm in, and I just wanted us to have clarity on how these two aspects of law intersect with each other. So in conclusion from my side, I say thank you so much, participants, for attending this session, and for us to know that in the digital market, data is power, and the more a platform has data, the more likely it is to engage in exploitative and exclusionary conduct. And because most consumers, especially from developing countries, may have limited knowledge on when to freely give their data, it becomes important that we continue having this discussion. So thank you so much, and bye to everyone.
Thank you.
Thank
Thanks
you.
so much.
Bye-bye.
Okay.
Thanks. Bye.